of global peace. When the seas are calm, navigation is simple. But when the waters grow turbulent, when unilateral claims cloud the horizon, and when the shadow of coercion looms, nations need something far more permanent than political convenience. They need a lighthouse. A lighthouse does not block the winds. It does not command the tides. It stands immovable upon bedrock, casting a steady, piercing beam to warn of hazards and guide all ships to safe harbor. 13 years ago, the Philippines courageously initiated these arbitral proceedings. And 10 years ago, on July 12, 2016, the Arbitral Tribunal handed down its historic decision. In doing so, our nation sought to build such a lighthouse. We did not do so for ourselves alone. We acted to speak for every nation, especially those who find in international law a vital shield against geopolitical uncertainty and the stark asymmetries of power. By authoritatively ruling that historic claims within the fictional 9-dash line have no basis in law, the 2016 Arbitral Award permanently illuminated once murky waters. It stands as a landmark triumph of peaceful dispute settlement. This award is final. It is legally binding. It is not a mere statement of policy. It is not subject to negotiation or compromise. It is an unshakable, permanent anchor of our rules-based international order. It replaced confusion with clarity. It established a fundamental truth under the United Nations Convention on the Law of the Sea, the very constitution of our oceans, that all states are sovereign equals. The beam of this lighthouse has reached far beyond our own coastlines. It is now an unassailable part of the corpus of international law, cited by tribunals and states alike, including the International Court of Justice and the International Tribunal for the Law of the Sea. Its principles apply not only to maritime entitlements, but to our most urgent global challenges, from protecting fragile marine environments to preserving biodiversity. Indeed, the theme of our commemoration today, a decade hence, the enduring promise of a peaceful dispute settlement, invites us to look beyond the immediate horizon. Throughout this day, we will chart this course together. Our sessions will examine the far-reaching impact of the 2016 award across our political and security landscapes, its vital role in promoting economic and scientific cooperation, and its profound continuing influence on ocean governance. As we look forward to the next decade, the Philippines' maritime statecraft remains guided by this light. Our approach is anchored on 4 core dynamics. 1, first, we maintain a steadfast commitment to international law. With UNCLOS and the 2016 Arbitral Award as integral anchors of Philippine foreign policy, we will navigate the complexities of our strategic environment with clarity, restraint, and resolve. 2, second, we keep lines of communications open. We will use this award as our clear, legal, and policy baselines to engage partners and pursue an effective, legally binding code of conduct in the South China Sea. Third, we maximize our alliances and partnerships. We will reinforce our capacities through purposeful engagement, because cooperation deters conflict, de-escalates tensions, and creates the conditions for peace. Fourth, we employ a confident, deliberate, and principled approach to our strategic landscape. We will ensure our domestic capacities are fully supported by a foreign policy that firmly asserts our interests and contributes to a peaceful, stable, and rules-based maritime order. Excellencies, to support the 2016 Arbitral Award is to support the very architecture of our rules-based international order. It is a quiet, powerful affirmation that right is greater than might. Let this commemoration be a space to keep this lighthouse burning bright, for its light is our commitment, its clarity is our peace, and its enduring promise is a stable, rules-based world for generations to come. Thank you. Maraming salamat po.
Thank you very much, Secretary Lazaro. May we request the Honorable Secretary to remain on stage for the next segment. As part of today's occasion, we proceed to the unveiling of the commemorative postage stamp. May we invite our distinguished guests to join Secretary Lazaro on stage for the formal unveiling. Postmaster General, the Honorable Maximo C. Santa Maria III, and the artist, Ms. Mary Joy Ann C. Tuanyo. May we now request our officials to proceed with the unveiling. Ladies and gentlemen, the commemorative postage stamp marking the 10th anniversary of the Thank you very much, Excellencies. You may now proceed back to your seats. Titled Paninindigan sa Alon ng Tamana after its lead painting, this special settlement collection are artworks created by Filipino visual artist Ms. Mary Joy Ann C. Tuanyo. Paninindigan sa Alon ng Tamana looks toward the horizon as a nation, while Pawikan in Bloom too looks inward toward the individual Filipinos' endurance and tie to home. The frame and the original paintings will be displayed at the foyer throughout the rest of the day. Thank you. The Office of the Solicitor General of the Philippines stood at the forefront of the arbitral proceedings. As the principal law officer and legal defender of the state, the Office of the Solicitor General played a critical and indispensable role in securing this historic ruling. To deliver her commemorative remarks, Excellencies, ladies and gentlemen, let us welcome the Solicitor General of the Philippines, the Honorable Darlene Marie Bravo. Your Honor, the floor is yours.
DFA Secretary Tess Lazaro, NSA Honorable General Eduardo Oban, DENR Secretary Juan Miguel Cuna, Japanese Vice Minister Honorable Tomoaki Shimada, POMC Secretary General Andres Centino, DFA ASEC Emmanuel Donato Guzman, PhilPost Postmaster General and CEO Maximo Santa Maria, distinguished Excellencies, colleagues in government, fellow servants of the Republic, friends of our proud nation, good morning. 10 years ago this month, an arbitral tribunal constituted under the United Nations Convention on the Law of the Sea handed down its award in the case our republic brought against the People's Republic of China. The other speakers today will probably speak of that day as a legal victory, which it was. They will reflect on the award's contributions to international law, as indeed the award gave much. They will consider its promise for the peaceful settlement of disputes, and no one may deny that promise is real. I have been asked to speak of something quieter, and I believe more durable. I am asked to speak not of what we won by the award, but of what it protects every day for 10 years now, and why that protection will endure. I speak from a particular vantage point. The Office of the Solicitor General stood as agent of the Republic in that arbitration. When the case began on the 22nd of January 2013, the Solicitor General stood beside the Secretary of Foreign Affairs as the notification and statement of claim was announced to the world. Our duty was to protect our client, the Republic of the Philippines. The heart of my message can be captured in 2 sentences. The promulgation of a judgment is an event, but a legal protection ought not to be a singular moment, but consistent practice. The South China Sea Award endures to this day not because it was rendered in The Hague, but because the Republic decided in our Constitution, in our laws, in our institutions, and outwards in our dealing with the world to live by it. Let me first recall how difficult the road to The Hague was, because the difficulty makes clear the reach of the award's protection. The road leads us back to 2009, when China formally asserted its claim to a 9-dash line. The line was contained in a map which was attached to its objection to the joint filing of Vietnam and Malaysia on the outer limits of their continental shelves under the convention. The map covered nearly all of the exclusive economic zone of the Philippines and its neighboring states in the South China Sea. Vietnam, Indonesia, and the Philippines protested China's map for being contrary to the UNCLOS, among others. Less than 3 years later, in April 2012, Chinese and Philippine vessels stood off at Bajo de Masinloc, the Scarborough Shoal, and the Scarborough Shoal. Scarborough Shoal lies some 124 nautical miles from the coast of Zambales. It always has been known as Philippine territory, where our fishermen regularly fished. It was what our forefathers knew. It was what our children knew. In 2012, Chinese law enforcement vessels began preventing Philippine vessels from gaining access to the shoal. These vessels dangerously approached Philippine ships twice, creating a serious risk of accidents, thereby violating the basic maritime rules that keep sailors safe at sea. The standoff, in fact, lasted 4 months. When it ended, our fishermen could no longer fish where their grandfathers had fished. The pressure was not only at sea. That same year, Philippine banana shipments met sudden barriers at Chinese ports and Filipino tour groups were canceled. Filing the case was not an obvious choice. No claimant state had ever brought these disputes to international litigation, and the legal path was deliberately narrow. But we needed clarity on rights over the waters surrounding the archipelago, particularly those in the South China Sea. No less than the livelihood of our fishing communities was at stake. The case was born by the most basic needs of our people. In August 2006, China had filed a declaration under Article 298 of the Convention, opting out of compulsory settlement for disputes over maritime boundary delimitation and over historic base or titles. So the Republic's lawyers had to thread a needle. We could not ask who owns the islands. Questions on sovereignty lie behind the convention. We could not ask where a boundary runs. By its declaration, China has excluded settlement of issues on the limitations. What we could ask was what the sea itself allows, whether a line of 9 dashes can create entitlements the convention does not recognize, whether certain features are islands, rocks, or low tide elevations as to give rise to rights over the surrounding seas, and whether China's conduct within our exclusive economic zone was lawful. On 22 January 2013, the Philippines filed on precisely those questions. As the DFA said that very day, our filing deliberately avoided every claim that China's declaration had placed beyond reach. China chose not to appear. That made our task harder, not easier. Under Annex 7, when a party is absent, the tribunal must still satisfy itself that it has jurisdiction and that every claim is well-founded in fact and in law. The tribunal upheld its jurisdiction in October 2015 and ruled on the merits on the 12th of July 2016. But while our case was being reviewed, China intensified the construction of a large artificial island on Mischief Reef, a low-tide elevation inside our exclusive economic zone. The tribunal later found that this caused severe, irreparable harm to the coral reef ecosystem at 7 reefs, that it permanently destroyed evidence of their natural condition, and that it aggravated the very dispute brought to The Hague. China told the world these works were civilian. That statement is the reason the tribunal had jurisdiction to condemn them. The Philippines did not come to the convention as a stranger. We signed it at Montego Bay in December 1982 and ratified it in 1984. We are among the earliest nations to do so, the 11th to be exact. And in the long negotiations before that, Filipino diplomats, together with Indonesia and other island nations, helped write the very concept of the archipelagic state into the law of the sea. Now, to the heart of the matter, what exactly does the award protect and how? Our attempt to answer this question must begin not in The Hague in 2016, but in Manila in 1987 with the Constitution. Article 12, Section 2 commands, the state shall protect the nation's marine wealth in its archipelagic waters, territorial sea, and exclusive economic zone, and reserve its use and enjoyment exclusively to Filipino citizens. I ask that we focus on the verb shall. The protection of the verb shall protect. The protection of our marine patrimony is not a policy that administrations may take up or set down as they please. It is a standing constitutional duty addressed to the state itself, which is to say, to every one of us in this room. But a duty needs definiteness. The reach of that duty was shadowed by a claim drawn in 9 dashes across the sea. If that claim had stood, it would have swallowed most of our exclusive economic zone. What the award supplied was certainty. It confirmed that within our exclusive economic zone, the Philippines holds sovereign rights, not sovereignty over the waters, but the exclusive right, ours and no one else's, to explore, exploit, conserve, and manage the resources of the sea, the seabed, and its subsoil. The award drew no boundary. It expressly declined to. What it did was lift the cloud. It held that the 9-dash line generates no entitlement to resources and that no feature China claims in the Spratlys generates an exclusive economic zone of its own. Our zone stands unshadowed. What does that mean in daily life? It means the fish that feed our coastal towns are in law Filipino fish. It means the gas beneath Recto Bank is in law Filipino gas, and that Bajo de Masinloc in law remains a traditional fishing ground from which our fishermen may not lawfully be barred. When we speak of enduring protection, we should see faces: the fisherman, the coastal family, the child whose food security was litigated in The Hague without her ever knowing it. Before the award in 2016, the Philippines successfully asserted in 2012 its entitlement to the Benham Rice region as part of its extended continental shelf, an area bigger than the whole island of Luzon. This entitlement and the award in 2016 reignited the maritime legislative reforms already began in 2009 when the Philippine Archipelagic Baselines Act, which sought alignment of Philippine baselines with UNCLOS, was passed. Both animated the codification of Philippine laws that align with the Convention. In November 2024, Congress enacted and the President signed RA number 12064, the Philippine Maritime Zones Act, and RA number 12065, the Archipelagic Sea Lanes Act. The Maritime Zones Act writes into our statute books the extent of our maritime zones, standing squarely on the Constitution and on the Convention. The Executive has described these twin laws, and rightfully so, as operationalizing the 2016 award. Beyond the award, therefore, what we see is a country that is steadfastly building its maritime rights by upholding the rule of law. Earlier this year, Executive Order number 111 went further still. Through this EO, the President directed our mapping authorities to publish charts bearing Philippine names for the features of the Kalayaan Island Group and reflecting the Maritime Zones Act. I invite you to trace the arc with me: a constitutional command of 1987, the legal certainty of 2016, the statute books of 2024, the 2026 directive to publish the charts. That is what enduring protection looks like in a republic of laws. An international award woven thread by thread into domestic legal obligation, paper into law, law into practice. But statutes and awards do not patrol the sea. Protection presupposes an enforcing republic, and I am looking at this room full of the people who do the enforcing. This has not always been the case. But since 2022, the Philippines has taken bolder steps in advancing the award and its protections. The Coast Guard has made a practice of publishing what happens at sea. Every event is recorded. Every record is potential evidence. We have now chosen to let the world see what has been happening, and by all indications, the world now pays closer attention. Then, in March 2024, Executive Order number 57 reorganized the National Coast Watch Council into the National Maritime Council. The National Task Force for the West Philippine Sea sits attached to that council. The Solicitor General is a member of the council. From that seat, I can tell you what enduring protection looks like on an ordinary Tuesday. It is the Coast Guard holding station in our waters with discipline under immense provocation, whether it be the use of water cannons, aggressive maneuvers, or confrontations at Ayungin Shoal and Bajo de Masinloc. It is BFAR standing beside our fisherfolk under the gaze of the Chinese maritime militia. It is NAMRIA drawing the charts. It is the Department of Foreign Affairs filing the protests patiently, one by one. It is the armed forces sustaining a presence that gives the law not merely a witness, but teeth. None of that is the Office of the Solicitor General's work. None of it. Our part is quieter. We are not the ships. We are the legal spine, and we provide the legal shield. The office exists so that every action the Republic takes at sea can be defended in every forum in which it may ever be tested, so that our conduct is always the conduct of a state that knows its rights and stays within them. There is a wider circle of protection I want to name before I close, because the award protects more than Philippine entitlements. It protects the character of the sea itself, and with it, interests far larger than our own. Consider what passes through the South China Sea. By UNCTAD and CSIS estimates, roughly a fifth of global trade, or around $3 trillion a year, and about a third of the world's shipping transit these waters. For an archipelago like ours, the stakes are existential. We import and export by sea. The energy that lights this room, the goods in our markets, the exports on which millions of Filipino livelihoods depend, these move along these lanes. And what is true for us is true for our neighbors, and likely for every trading nation on earth. Now recall what the 9-dash claim was at bottom, a claim to enclose nearly an entire semi-enclosed sea. By holding that maritime entitlements can arise only from the convention, the award kept the South China Sea what the law says it must be, a sea governed by rules in which navigation and overflight, commerce and cables, fishing and science each have their lawful place. That certainty is a security good in the strictest sense. Instability at sea is priced into every insurance premium, every rerouted voyage, every delayed cargo. Law remains the least expensive security architecture ever devised, and the award is load-bearing law. And here is the part I say with quiet pride. The Philippines asks of the law only what it gives. The same Congress that fixed our maritime zones in 2024 also passed the Archipelagic Sea Lanes Act, designating the routes through which foreign ships and aircraft may pass through our archipelago in the manner the convention provides. We claimed our rights and in the same breath honored everyone else's. That is the conduct of a state that believes in the system it invoked, the same state that helped write the archipelagic regime in 1982, that ratified early in 1984, that filed its case carefully in 2013, that codifies that law faithfully today. National security, regional stability, freedom of navigation, the flow of commerce, these are not subjects separate from the award. They are what the award kept alive quietly underwrites for us, for our nation, for the region, and for generations to come. Administrations change, emphasis shift, budgets rise and fall. The Republic, however, is a continuing client, and this decade's work has moved the award's protection beyond the reach of any single season of politics. The award lives now in the Constitution's standing command, in 2 statutes of the land, in standing institutions that meet whether or not the news is watching, in charts our children will study, bearing our own names for our own features. The Office of the Solicitor General is the law firm of the Republic, and its lawyers, tribunes of the people. The instruction is clear and unmistakable. Protect the nation's marine wealth for Filipinos and for the Filipinos yet to come. An award is paper until a republic chooses to live by it. For 10 years, through every test, the Filipino has chosen to live by the award. The award's protection endures because the choosing continues in the council, in this department, in this room, in every statute and every chart, in every protest patiently filed, and every fisher who puts out to sea because our Constitution says it is national patrimony and because the law of nations says he may. Maraming salamat at mabuhay po tayong lahat.
Thank you, Solicitor General Berberado. The 10th anniversary we commemorate today belongs not just to the Philippines, but to all the nations and partners who have shared in this journey. We are pleased to share a special pre-recorded message from the Minister for Foreign Affairs of the Commonwealth of Australia, Senator the Honourable Penny Wong.
I'm Penny Wong, Australia's Minister for Foreign Affairs. I would like to extend my greetings to the distinguished guests in attendance today, particularly my friend Foreign Secretary Lazaro. I'd also like to acknowledge the Philippines' important leadership role as this year's ASEAN Chair. It's a pleasure to address this forum on this important anniversary, which coincides with the 80th anniversary of diplomatic relations, friendship and partnership between Australia and the Philippines. 10 years ago, an arbitral tribunal constituted under the UN Convention on the Law of the Sea, UNCLOS, made a unanimous, clear and binding ruling in the South China Sea arbitration between the Philippines and China. The 2016 arbitral award ruling was a landmark decision. Since the day of that ruling, Australia has consistently called for the Philippines and China to abide by the ruling. We have done this and will continue to do so because Australia believes that we all benefit from a region that operates by rules and norms. We want each country, large or small, to operate by the same rules that we have all had a say in shaping. And when disputes inevitably arise, we insist those differences are managed through dialogue and according to the rules, not by force or by raw power. These are principles embedded in our region, and the countries of our region make an ongoing contribution to maintaining and promoting them. Respect for law of the sea has never been more important to our shared economic security and our prosperity. And even as the world order is fundamentally changing, and because it is changing, Australia stands for rules and institutions. We believe they are fundamental to the character of our region, which is why we will continue to register our concerns about Chinese vessels engaging in destabilising and dangerous conduct in the South China Sea, including towards Philippine and Vietnamese vessels. Australia is acutely aware of these challenges, which is why we are investing $160 million over 10 years to expand our maritime cooperation with our Southeast Asian partners, particularly the Philippines. This cooperation is supporting partners to boost maritime domain awareness, implement maritime governance reform, and protect the marine environment. This year, we also announced the doubling of our bilateral maritime assistance to the Philippines through a new $18 million four-year investment. In our 80th year of diplomatic relations, our defence cooperation with the Philippines continues to grow. This is reflected in joint exercises like Exercise Balikatan and Exercise Alon, as well as our multilateral cooperative activities. For a country like Australia, we know we are made stronger by what we do together. And this is a central part of how we think about ASEAN centrality. ASEAN has a unique voice. By its words and deeds, it can build norms and it can set expectations for powers great and small. So, friends, we may be bound by the geography that fate has chosen for us, but we are strengthened by the partnership that we choose for ourselves. I congratulate the Philippines on convening this important conference, and I look forward to strengthening our partnership in the years ahead. Thank you.
We thank the Honourable Minister Wong and the Government of Australia for this message and for Australia's steadfast partnership in upholding the rules-based order in our region. To deliver a special message from the Government of Japan, let us welcome the Parliamentary Vice Minister for Foreign Affairs, His Excellency Tomoaki Shimada.
Magandang umaga po. Honorable Lazaro, Secretary of Foreign Affairs, Honorable Berberabe, Solicitor General, Honorable Kuna, Secretary of Department of Environment and Natural Resources, Honorable Obam, Nation Security Advisor, Honorable Centino, Secretary of Presidential Office for Maritime Concerns, all those in attendance. I'm Tomoaki Shimada, Parliamentary Vice Minister for Foreign Affairs of Japan. Following the state visit of President Marcos and the First Lady in May, and the visit of Secretary Lazaro in June, it is a great honor to visit the Philippines and speak in front of you today at the commemorative conference on the 10th anniversary of the Arbitral Award. The Arbitral Award in 2016 marks a crucial milestone concerning the South China Sea, highlighting the importance of the peaceful settlement of disputes in accordance with the United Nations Convention on the Law of the Sea, UNCLOS. The attendance of government officials and experts from various regions in this conference underscores the significance of the Arbitral Award. Japan highly appreciates and strongly supports the government of the Philippines' consistent emphasis on the rule of law and its position in accordance with the Arbitral Award. The South China Sea is a vital sea lane not only for the region but also for the international community as a whole. For Japan, as a maritime nation that has been supported by a free and open maritime order, the freedom of navigation and overflight, as well as peace and stability in this region, are of great significance. Against such a backdrop, Japan is seriously concerned that unilateral attempts to change the status quo by force or coercion, which threaten regional peace and stability, have continued and strengthened in the South China Sea over the past 10 years. Unilateral attempts to change the status quo by force or coercion are unacceptable anywhere in the world. Japan will continue to consistently reiterate its position that disputes should be resolved peacefully in accordance with international law. In line with this position, Japan has been advancing concrete initiatives towards realizing a free and open Indo-Pacific, FOIP, and consistently supporting the ASEAN outlook on the Indo-Pacific AOIP, which is a key principle for ASEAN in this region and shares fundamental principles with FOIP. In the maritime domain, Japan has been continuing capacity building activities for the Philippines Coast Guard, including through the provision of patrol vessels and joint training. Furthermore, maritime concern among Japan, the Philippines, and the United States is also making steady progress. Japan and the Philippines are neighbors across the sea. The Philippines, with which Japan shares the fundamental values and principles, is one of the closest like-minded countries for Japan. Under our comprehensive strategic partnership, we intend to continue strengthening our relationship in a sustained and multi-layered manner, including our response to issues concerning the South China Sea without being swayed by changes in the international environment. The arbitral award is final and legally binding on the parties to the dispute, rendered through proceedings based on UNCLOS. Respect for this arbitral award is critically important to ensure practical effect to the principle of the peaceful settlement of disputes under UNCLOS. No single country can maintain and strengthen a maritime order based on the rule of law alone. Japan will continue to play a proactive role in coordination with its allied, like-minded countries and ASEAN member states based on the core principles of FOIP, such as freedom, openness, diversity, inclusiveness, and the rule of law. In closing, I would like to express my respect to all those who have worked so hard to organize this conference and my best wishes for further development of our friendship. Maraming salamat po. Thank you.
Thank you, Your Excellency, and to the Government of Japan for its continued partnership in upholding the rules-based international order. At this juncture, we would like to call on the Assistant Secretary of the Maritime and Ocean Affairs Office, Attorney Emmanuel Donato K. Guzman, to provide an orientation on this afternoon's simultaneous breakout sessions. Assistant Secretary Guzman, the floor is yours.
Good morning, everyone. Honorable Secretary of Foreign Affairs, Maria Theresa P. Lazaro. Honorable Secretary, National Security Advisor, Secretary Eduardo Oban. Honorable Secretary of Environment and Natural Resources, Juan Miguel Cuna. Presidential Assistant for Maritime Concerns, Honorable Andres Centino. Honorable Solicitor General Darlene Marie Berberabe. Vice Minister Tomoaki Shimada. Excellencies, ladies and gentlemen, good morning. The remarks this morning have truly underscored the meaning and significance of the Arbitral Awards milestone year. Secretary Lazaro opened by strongly affirming the enduring relevance and importance of the 2016 Arbitral Award. Solicitor General Berberabe then traced, with the full authority of the office that helped secure the award, the Philippine experience and how the award has become the great protector of the nation. As the Solicitor General said, the Republic chooses to live by it. We are pleased to hear the expressions of solidarity of two maritime partners, the message of Minister Wong of Australia and the statement of Vice Minister Shimada of Japan, both reaffirming their government's steadfast support for the award and for the peaceful rules-based settlement of disputes at sea. Ladies and gentlemen, this conference is not just a commemoration in the retrospective sense. Rather, it is a working session on the Arbitral Award's continuing significance, meaning, and importance. In designing this commemoration event, the Department of Foreign Affairs envisioned a collaborative approach with our many international friends and partners. So later this afternoon, We will welcome speakers and experts from Canada, the High Seas Alliance, the European Union, Australia, New Zealand, Japan, the Netherlands, and the United States. This afternoon's conference will convene in the Track 1.5 format. 3 simultaneous breakout sessions, each designed to take up distinct dimensions of the award's legacy. This structure gathers government officials, jurists, scientists, scholars, and students in the same room, so that theories and positions may be tested against academic and technical rigor. Track A, the political track, examines the geopolitical implications of the award. The guiding question, how much has the 2016 South China Sea Arbitral Award influenced state behavior in the SCS and shaped a rules-based order in the global maritime domain? Track B, the economic and scientific track, will take up environmental stewardship, resource management, and the blue economy. Finally, Track C, the legal track, will take up international jurisprudence and comparative legal studies. Specifically, how can international law sustain peaceful settlement of maritime disputes? Each track will be supported by a designated moderator whose task is to distill forward-looking takeaways for the plenary roundtable that will follow this afternoon. The takeaways will be brought together to inform our synthesis discussion afterwards on sustaining the rule of law at sea over the next 10 years. We encourage every delegation to engage across the 3 tracks and the subsequent synthesis. It is my hope that much will be learned and more will be inspired. In these next few hours and in this conference, that it will leave us not only better informed, but renewed in our resolve to carry forward the very principle the Arbitral Award has left us. That disputes, however difficult, are best resolved not by force, but by law and in peace. Thank you very much, and we look forward to seeing you all at the respective breakout sessions this afternoon.
Thank you very much, Assistant Secretary Guzman. Before we break for lunch, we would like to have a brief photo opportunity with our Secretary of Foreign Affairs, opening plenary speakers, senior officials, and all the moderators and panelists. May we request the following individuals to join us. You will be assisted by our protocol officers. Honorable Juan Miguel Cuna, Honorable General Eduardo Oban Jr., Honorable Darlene Marie B. Berberabe, Honorable General Andres Centino, Honorable Alana Samantha T. Santos, Honorable Tomoaki Shimada, PhilPost Postmaster General and CEO Maximo Santamaria III, and Assistant Secretary Emmanuel Donato K. Guzman. After this brief photo opportunity, we would like to also request our moderators and panelists to please join. One, two, three. 1, 2, 3. Thank you. And now, may we request our moderators and panelists to please join our excellencies up front for a brief photo opportunity. Our protocol officers will be assisting and guiding everyone. Thank you. Once again, we request all moderators and panelists to please join our excellencies and dignitaries up front for a brief photo opportunity. Thank you. Once again, we ask all moderators and panelists to please join. May we now, at this point, ask everyone, all our guests, to please rise to join in the group photo for posterity. Thank you. Everyone, if you see the camera, you're on the photo. All right. 1, 2, 3. 1, 2, 3. One more. 1, 2, 3. Thank you very much, everyone, for this opportunity. Ladies and gentlemen, that concludes the opening plenary of our National Commemorative Conference. Lunch is now served. Guests are invited to proceed to their respective lunch venues. We shall reconvene at 1 p.m. for the simultaneous breakout sessions. To ensure an orderly flow of guests for lunch, may we first invite all plenary speakers, Philippine government officials, and members of the Diplomatic Corps to proceed to Brasserie on 3. Panel experts and moderators for the breakout sessions may proceed to the Roosevelt Room. We also invite our media friends and students to proceed to their assigned area at the Sea Lounge. Please follow the signages leading to your designated lunch venue. Should you need assistance, please approach any of our ushers or secretariat staff. We look forward to seeing everyone back here at the plenary at 3:30 p.m. for the closing synthesis and roundtable discussion, following the breakout sessions. Thank you, and we wish everyone a pleasant lunch.